Hello, I'm Sarah Thompson-Copsey and welcome to today's session for Legal Futures, Ambiguous Drafting in Property Contracts. Whenever we as lawyers look at a document that's been drafted, whether it's a lease or it's a sales contract or it's an overage agreement or a development agreement, there will often be times when we look at that document where we think, I'm not quite sure what that means. Usually, it's never going to be a problem whatsoever, and very fortunately, in the vast majority of cases, even when the drafting has totally gone wrong, we don't have a problem with it because the parties actually agree whether or not the contract deals with it, the parties actually agree how they're going to behave. But problems can arise where there is a dispute between parties, where you need to go back to the contract to work out what is actually happening. And in those circumstances, it's important to know how the courts will look at the lease you're looking at, how they'll look at the overage agreement you're looking at, because that informs the advice that you give to your clients. And it also informs the way you draft going forward. Obviously, the drafting that you're looking at that might have a little problem with it isn't your drafting, it's the other idiot's drafting. But you can learn lessons from that and from the court's approach to problematic drafting, ambiguous drafting, from the court's approach that can inform how you draft going forward. So we're going to be looking at the ways in which the court actually approaches the problem areas within your document. For example, you want to forfeit the lease. What actually triggers the right to forfeit? Is there a need to serve a notice? If so, what sort of notice? If you're looking at an overage agreement, has that agreement been triggered? Can the developer actually be forced to pay money to the original landowner in the way of overage? Or has that obligation not yet been triggered? In the sales contract, are the parties now in a position that the sale and purchase must be completed, or are there conditions that remain outstanding? So all of those types of agreements, those property agreements, require the court, if it cannot be resolved elsewhere, to actually look at what does the drafting that we've put in the document actually mean. And the court looks at that in 4 different ways, as you can see here, and looks at interpreting the contract as it stands. So looking at the words, how will the court actually approach those words, and how strict is the court's approach to the words we've put into documents following the cases of Arnold and Britton and Wood and Capita, both of which we're going to look at in just a moment.